My aide and traveling companion, Major Statesmanship, prepared me a statement for you here. This is a Tea Party group. A three-legged stool can be stable if all legs are equal. But if one, such as the judiciary leg, is bigger or too powerful, then the stool or the government will be out of balance. Conservatives or Tea Party patriots have focused our efforts on the elected branches of government, the executive and legislative branches. Under the Founding Fathers, designed in this Constitution for the United States of America, both a balance of powers and a separation of powers is accomplished by three branches of government. Two branches of those which have bicameral arrangement. That is to say, in the legislature we have a bicameral legislature with the Senate and the House. And in the judiciary we have a bicameral judiciary with judges and juries, with the legislature responsible for regulating the judiciary. That's not a separation of powers problem. Both by discipline, appointment, reappointment, removal, or even impeachment, and by constraint, definition of what areas of law and rights are eligible for judicial review. Like the legislature is composed of the people's house to balance the elite Senate, the founders considered the jury essential to balance the elite judges. One major problem was created under the time of Democrat Franklin Roosevelt. The voluntary bar associations became a compulsory union and an agency of the Supreme Court of each state, with lawyers becoming officers of the court, with duty to the court before duty to the client. In Virginia, this unconstitutional development happened in 1938. Then there is the violation of the separation of powers, when a bar member is elected to the legislature because there is a conflict with the judiciary discipline and constraint duties of the legislature, necessary to maintain the constitutional balance of powers. Because, at least in part, the lawyer is an officer of the court, a branch of government that as a legislator, he has a duty of oversight, thus placing the bar member legislator in a conflict of interest position. Former Washington Post investigative reporter Stephanie Minsimer, in her book Blocking the Courthouse Doors, tells of how Karl Rove was involved in the election of various state Supreme Court justices to control that branch of government, as well as control by various big business interests. The biggest big business, self-serving interest is the bar industry that controls our courts. I said our courts. Today we have barbarians at the gates, barring justice to the citizenry, barring justice to the rest of us lowly commoners unless we pay the extortion payments. The judges are the big barbarians, the lawyers are the little barbarians, both members of a self-promotion and protection union called the Bar, with its mandatory membership. Where is the citizen's freedom of choice? The courts have become the bar's exclusive playground, a sandbox where barbarians sandbag citizens, with well-nigh legal extortion by bar member lawyers who charge exorbitant fees, and bar member judges who order crippling fines and penalties that suck the financial lifeblood from the American man and from his family. Yet, who can promote the average citizen's, American citizen's interests in the court? The answer is we, the people, citizens, acting in a jury. The jury is the only democracy in this, our representative republic. Action in the grand jury that can again receive presentments from fellow citizens against elected servants who rape the law or ignore the law. We citizens use the grand jury power to issue indictments against those self-serving servants. No more sovereign immunity for bad police or corrupt prosecutors. No more judicial immunity for biased judges or judges who legislate from the bench. Servants who violate the spirit of the Declaration of Independence that said as a core value that even the king had no immunity when he violated the law. We must eliminate sovereign immunity and judicial immunity if we are to reclaim our republic, because the courts are where we can take elected servants to a level playing field and redress our grievances in the courts. If the courts aren't fair, we don't have that opportunity any longer. Now, as we the people acting wisely in a trial jury to say no to a law passed by the legislature that is not fair or just. So we nullify this law, a constitutional concept called jury nullification that judges hate. Or in the alternative, this law is not being fairly enforced by the police or prosecutor in the case. So we, the people in a jury, find the verdict in the case not guilty for a fellow citizen and protect our own future from protectors who become predators. Now, this is a third aspect of the stool of a balanced government. We, the people, have to take action.